Growing calls for the removal of the Texas judge in the controversial Affluenza case. Some people even petitioning the governor to have her ousted. It's all about a 16-year-old, Ethan Couch, who was sentenced to 10 years probation and treatment after a DUI incident that killed 4 people. The defense said he suffered from affluenza, which refers to an upbringing so privileged the person doesn't know right from wrong. Was the judge's ruling wrong? Should she be reversed? To Fox senior judicial analyst, Judge Andrew Napolitano. New information coming in, by the way. A report that this young man lived in a mansion alone, and the mansion was given to him by his father. Now, doesn't that make the excuse of affluenza even more viable?
No. I don't think the excuse of affluenza, a term with which I'm unfamiliar until this case, is viable at all. You see, in American courts, before a scientific defense may be asserted, there must be a substantial acceptance of the defense in the scientific community of which the witness is a part. So this psychiatrist who said, because of a privileged upbringing, this boy didn't know right from wrong, is the only person in the country who's preaching this. Therefore, the judge should have rejected it as a viable defense. When I say defense, it's not a defense to what he did. It's an effort to lessen the sentence.
Precisely.
He pleaded guilty to vehicular homicide.
But isn't there a point here? I mean, if this young man, 16 years of age, is given a mansion, he lives there alone, isn't that asking for trouble? Isn't it asking for him not to know right from wrong?
I would think that the estates of the decedents, the parents and the descendants of the decedents, people killed by him, would have a cause of action against this young man's father for placing the young man in a situation not of privilege, but of utter and total luxury without restraint, which might have messed up his thinking and his judgment so much.
There could be grounds to go after the wealth of the parents in this case.
Yes, but this living in the mansion alone has never been accepted by a court as a basis for reducing a penalty or removing guilt because of him not knowing right from wrong.
Okay, I've got to move on because there's a very important, was it a ruling or a statement from a judge who said the NSA's spying on phones is almost certainly unconstitutional. Have I got that right?
Yes, and
it's very important.
Yes, the reason for the almost certainly is this is a preliminary ruling, and the judge stayed the effect of the ruling until it can be appealed to a higher court. But basically, some plaintiffs, people who use Verizon, and almost certainly were among the 113 million whose phone records were initially seized, filed a complaint saying, this violates my constitutional rights. I want it stopped now. Now, when you ask for immediate relief, this is not the final resolution. It's an immediate decision. The judge has to decide, are you likely to prevail? If you are likely to prevail, are you harmed now? If you're harmed now, are you entitled to immediate relief? The judge answered all 3 of those questions, yes. And in deciding, are you likely to prevail, he basically said, the Constitution does not permit the Congress to authorize the FISA court to authorize this kind of spying. That if you want to spy on somebody for a day or so, you could probably do it. But to spy on everybody, quote, world without end, I'm quoting the case, these are not my words, is an absolute and direct violation of the 4th Amendment.
Are you going to keep me safe, Judge, by declaring this unconstitutional? Do we deny the government the ability to track potential terrorists and their phone records?
You know, I sat on the bench in our home state for many years. I probably signed hundreds, maybe thousands of search warrants. If the police came to me and said, we want a search warrant for everybody in this zip code because we're looking for one bad guy, I wouldn't have signed it. And no
Hold on, Judge.
Judge in the state would have signed it.
There's search warrants and search warrants. This is to ask for tracking of phone numbers and phone calls, not necessarily to listen into them.
The tracking of the calls, and the judge articulates this in the opinion, results in the preservation of the conversation to which the NSA has access forever, for as long as they keep the records. Are you going to be kept safe? The appropriate question is, are you going to be kept free?
We shall discuss this at length, I am sure.
Yes, we shall.
Judge Napolitano, thank you very much.
Show that starts at 9:20 in the morning called Vonnie and Company.
That will be me. Watch it, by the way, because tomorrow morning, next time you go shopping in a mall, you may actually end up shopping online, a new trend about to take hold. We will discuss it in detail tomorrow, 9:20, Vonnie and Company. Right now,